4.1 Introduction. Adjudication process that comprises of several sub-processes such as taking cognizance, framing of charges, hearing prosecution and defense etc. is the core function of the criminal justice system, CJS. The court as an adjudicatory agency has to separate truth from the falsehood, relevant from the irrelevant and finally filter the admissible evidence for application of the law in force at the time of commission of the crime. In this process, a number of segments of the justice system are involved, however, the main agencies being police, prosecutor and the defense counsel. The judiciary has to strike a balance. The courts in India play a key role in the judiciary process. The court are vested with the difficult responsibility of balancing the interests of the society and victim on one hand and the interests of the accused on the other. This is to be done while upholding the rule of law and dispensing justice to the accused or the victim or the society. The prosecution has to represent the state on behalf of the victim and the defense counsel represents the accused person. Both the prosecutor and the defense counsel have to assist the court in analyzing the facts in the light of the existing laws. In this unit, an attempt has been made to discuss the adjudicatory process, its historical perspective, hierarchy and role of the courts and rights of the accused person during the adjudicatory process. 4.2 Adjudication process. Whenever a crime is committed, the adjudication process cannot come into motion unless someone reports the incident. It is true that police is the first agency in the criminal justice system and is expected to extend protection to every individual and record information about every crime that is committed within their jurisdiction. But due to the vast and diverse dimensions of their jurisdiction coupled with population explosion and migration of the people from one area to another, it is practically not possible to protect every individual. Moreover, police does not come to know about each and every incident which takes place within their jurisdiction. In order to make the judicial process effective and meaningful, it is essential that the complaint, witnesses rather the community, society as a whole, has to come forward and provide the relevant facts to the court through the investigating agency, i.e., police. It may be noted here that filing of FIR is an important first step to initiate the judicial process and therefore, the community support and cooperation is very important in the entire adjudication process. Adjudication process includes the legal battle which in the criminal cases takes place between the prosecutor and defense counsel in the court of law under the supervision of the judicial officer, i.e. judge. The basic purpose of the judicial process is to separate truth from the bulk of the cooked-up stories with exaggerated facts. The witnesses support the system by reporting what is within their knowledge regarding the event and the court plays very vital role in the entire judicial process. 4.3 Historical perspective. A brief historical review of the Indian judiciary reveals that justice in the ancient India was fast and economical. It was within the reach of every individual. The judiciary in India has crossed through many stages. The present judicial setup, in way, is by and large replica of the judicial system which was in vogue during the governance by Hindus and Muslims, modified by the English regime in the British Raj in India. Almost all the terms concerning the court nomenclature like Adalat, court, Faujdari, criminal, Dawa, suit, Gawah, witness, Muddai, complainant, Mudda Alahe, defendant, Zamanat, bail, and Vakil, lawyer, are in vogue in the present judicial process. The customs and rituals play a very important role in any society to coin as to what act does or does not amount to a deviant behavior and also lays down the mechanism to determine as such. Misra, 2004, has pointed out that criminal justice structure and justice process has an intimate connection with the social structure. Social structure is not a static phenomena nor can it be equal to the normative prescriptions of a sanctioned system, because many values are adopted locally and followed by the people as scrupulously as the sanctioned values. Law either leads or lags in prescribing or approving a social behavioral norm. Law regarding sati falls within the category of lead statutes, as it restructures the social norms on rational reformative lines. On the other hand, where laws simply recognize certain value patterns already existing in the society and are in vogue without any operational difficulty, fall within the category of lag statutes. The concept of crime and punishment is a relative term which is directly linked with moral values, ethical background and social mores of the society. Witnesses are the other key players in the process. Weston, 1967, has pointed out that the judge's role is to ensure that the issues are joined within the legal system, and in the three-sided interaction, the court must become place where a fair balance is struck between the rights of the state and rights of the individual. Gluck and Gluck, 1939, have observed that in the adjudication process, the courts are the mouth of a great hopper, into which the police pour thousands of cases of the alleged criminals. The judicial process is logically the process to filter out the guilty persons from the huge bulk of the accused persons. 4.4 Hierarchy and Role of the Courts. The hierarchy of the criminal court in India is based on the English pattern of judiciary. Section 6 of the Criminal Procedure Code 1973 provides that besides high courts and the courts constituted under any law other than code, the hierarchy of the courts shall be as under: I. Court of Sessions. A. Metropolitan Magistrate in any metropolitan area, and B. Judicial Magistrate of first class. Judicial Magistrate of the second class. IV. Executive Magistrate. The courts mentioned above are the courts constituted under the Criminal Procedure Code. In addition, special courts may be constituted under the special legislations as well as the Juvenile Justice, Care and Protection of Children Act 2000 that provides for constitution of juvenile justice boards. The law relating to the administration of criminal justice is contained in the Criminal Procedure Code 1898, amended from time to time. The important amendments were introduced by the central legislation in 1923 and 1955. The amendments introduced by these legislations were extensive and directed to simplify the procedure and speed up trials as far as possible. The amendments in question could not bring the desired results as the basic age-old code remained unchanged. There was general feeling among the lawmakers and legal fraternity that the basic code needs tremendous changes. However, no serious effort could be undertaken till Central Law Commission was set up in the year 1955. A comprehensive review of the laws pertaining to the administration of criminal justice was undertaken by the Law Ministry. A systematic examination of the Criminal Procedure Code was undertaken by the Commission, and after in-depth examination of all the provisions of the code, the Commission submitted its report. The government, on the basis of various law reform recommendations, enacted the Criminal Procedure Amendment Act 2005 and the Criminal Procedure Amendment Act 2006, and is in the process of notifying the Criminal Procedure Amendment Act 2008. 4.5 Concept of Justice. Justice is a relative term and everyone looks at it from his own perception. Justice, in its general terminology, means justice as perceived by an impartial arbitrator, presiding officer, judge who has no interest whatsoever in the case. It is rightly said that law is blind, but justice is not blind. Justice should be transparent, rather. Justice should not only be done, but should appear to have been done. To ancient India, the idea of justice was associated with fairness and expedition. Justice during Hindu period was short and swift. The basic tenets of criminal justice were compensation to injured, tax to the state, and imposition of certain conditions, if the offender was not dealt with death or banishment. Justice in the Muslim period was cheap and within the reach of every individual irrespective of his/her status and resources. The courts were held in the mosques and the judges were asked to treat the parties politely and without a frown on their faces. The Mughal rulers were very much interested in the cheap and speedy delivery of justice. Emperor Akbar asked his judges and governors that those who apply for justice be not inflicted with delay and expectation. He further asked the judges let them shut their eyes against the offences committed and accept the excuse of penitent, and there be no discrimination on account of sect or religion. This system of administration of criminal justice was in vogue when East India Company spread its domain in India. Judiciary in India during British period maintained status quo in respect of the administration of justice, both civil and criminal. However, with the extension in their domain and sphere of activities, East India Company confronted operational difficulties, and in order to overcome the operational difficulties and to serve their vested interests, they started to rely upon English law initially for information and guidance. However, with the passage of time, a new social order and administration was set up on the Western pattern. The system was changed from one man administered justice to that of the multi-institutional machinery, through a long-drawn procedure of apprehension, detention and trial, leading to the judgment. 4.6 Speedy and Fair Trial. The speedy and fair trial is essential for delivery of justice to the concerned. It is rightly said that justice delayed is justice denied. In the civilized societies, it is an accepted principle of law and natural justice that a person accused of a crime cannot be punished unless he has been given a fair trial, and fair trial means that the accused must be in a position to defend his case in the court of law with the assistance of a competent lawyer. If he is not in a position to engage a lawyer, he is to be provided one at the cost of the state exchequer. A judicial trial can't be fair unless both the parties, i.e., prosecutor and defense, are given an opportunity to explain their stand in a free atmosphere on equal footing. Kelkar, 1972, in respect of the fair trial, has pointed out that the notion of fair trial, like all other concepts incorporating fairness or reasonableness, can not be explained in absolute terms. Fairness is a relative concept, and therefore, fairness in criminal trial could be measured only in relation to available time, resources and the prevailing human values in the society. The fair trial no doubt is a relative concept, but the essential basic attributes of fair trial are enshrined in Article 10 of the Universal Declaration of Human Rights, which have been adopted and proclaimed by the General Assembly on December 10, 1948, which reads as under: Everyone is entitled in full equality to fair and public hearing by an independent and impartial tribunal in the determination of his rights and obligations of any criminal charge against him. The Supreme Court of India in Talab Haji Hussein's case, 1958, pointed out that the primary object of the criminal procedure is to ensure a fair trial of the accused. The law provides fair opportunity to the accused to defend his case and, subject to certain exceptions, starts the criminal proceedings with the presumption of innocence. This gives birth to the legal contest between the prosecutor and the defense counsel. The judge more or less acts like an umpire between the two contestants. In other words, the adversary system of criminal justice system provides that the prosecution, defense counsel and judge are to work together to find out the truth. 4.7 Rights of the accused. Activism has identified the rights of the accused persons for the speedy and fair delivery of the justice. Some of the important rights in this regard are identified as under: A. Notice of accusation. The fair trial demands that the accused person must be informed of the precise nature of the charge, so that he can prepare his defense accordingly. B. Arraignment. All charges which are against the accused must be explained to him in the terminology in which he understands it. Arraignment must be done at the earliest possible opportunity. C. Definiteness of penal statutes. The charges must be clear and under definite and clear penal statutes. A criminal statute must establish a normative standard which is definite and unambiguously clear, to which one can adhere, structuring his conduct. D. No self-incrimination. The accused has a right that he will not be subjected to self-incriminating questions. A. Unreasonable arrest, search and seizure. The accused has a right that he will not be subjected to unreasonable and illegal searches and seizures. He has also the right to protection against the arbitrary arrest. F. Near relations to be informed. The accused has a right that his near relatives shall be informed about his arrest. The government has a bounden and fundamental obligation to inform the near relatives of the accused where he is being taken and where he shall be lodged. G. Impartial judge. The accused has a right that he shall be heard by an impartial judge. The impartiality of the judge is very important, as justice should not only be done, but it should appear to have done. H. Impartial prosecutor. The accused has a right of impartial prosecutor, who is expected to serve both the state as well as accused. I. Competent defense counsel. The accused has a right to be represented by a competent defense counsel. The indigent accused has a right to the defense counsel at the expenses of the state exchequer. J. Right of speedy and fair trial. The accused has a right to speedy trial in the court of law. He has a right that court will ensure the fair and impartial trial. K. Presumption of innocence. The accused person has a right that he shall be presumed innocent unless proved otherwise in the court of law. The benefit of doubt, if any, shall be given to the accused person. The Malamud Committee has recommended that the concept, beyond reasonable doubt, in respect of presumption of innocence, under the present system be replaced by the lower standard of the court's conviction. This recommendation has been also subjected to criticism. L. Right to call witnesses. The accused has a right to call witnesses and confront the adverse witnesses through cross-examination. M. Right to reasonable bail. The accused has a right to be released on reasonable bail, subject to the provisions of the procedural laws. This feature of criminal justice has a special cogency, because majority of the persons processed in the criminal court are poor. N. Right to set off. The accused has a right that the period of detention already undergone by him during the trial is to be adjusted against his sentence in the same class. 4.8 Summary. The judicial process is a mechanism to determine the guilt of the accused person in the alleged crime. It means to bring law into motion against the accused person in order to establish his guilt or otherwise, in accordance with what is legally called due process of law or procedure established under law. The judicial process brings the prosecutor on behalf of the victim through the state and the defense counsel on behalf of the accused person together to present their case before an impartial person who is well versed in the law of the land. The judicial process in India has a long historical background. It has traveled from the ancient India to the present position through many stages and has been influenced by the Hindu law during the Hindu period, Muslim law during the Muslim period and English law during the British era. The lower judiciary up to the district and sessions courts, broadly speaking, is divided into civil, Dawani, court and criminal, Faujadri, court. At most of the places same court enjoys both civil as well as criminal jurisdiction. The hierarchy of the criminal courts in India is based on the English pattern of judiciary. The hierarchy of the criminal courts in India is provided under Section 6 of the Criminal Procedure Code, 1973. The prosecutor, the defense counsel and the court play a very important role in the dispensation of justice. All the segments of the criminal justice system are expected to work in close coordination with each other. The different segments of the criminal justice system are by no means exclusive of one another, but are interdependent upon each other. What is done in one subsystem has a direct bearing upon another, and they interact with each other at many points in the criminal justice process. In the adversary criminal system, all the segments of the system have a very vital role in the judicial process. The state, being the guardian, has to ensure speedy and fair trial. It is rightly said that justice delayed is justice denied. The judicial process cannot be effective unless there is quick disposal of the cases. But it is a matter of fact that there is inordinate delays in the disposal of the cases, and the judgments are delivered when the event stands washed away from the memory of the people. The community support is very important for the speedy justice, but people generally hesitate to come forward to assist the criminal justice authorities unless compelled by the personal considerations or compelling circumstances. The accused has legal and constitutional rights, which are being hardly adhered to during the trial. In order to ensure just and fair trial, the rights of the accused person should be given due recognition at every level. Thank you for watching. We will see you in the next video with the next chapter.